Hi there, Arizona attorney David Enevoldsen here, and in this video I want to talk to you briefly about the various discovery tools, that is, the process by which you can get information from the other side in a family court case in Arizona. Now, just by way of background, I want to explain what discovery is, and that is essentially the process of getting stuff that you need for trial. Because typically when you start the case, you don't have everything you need. You might need some answers to some questions from the other side. You might need some documents. You might need something out there that's going to build your case in the event that you end up in trial. Discovery is that process. It's just getting that information, going through that process of finding things you need, that sort of thing. Within the realm of discovery, there's a couple of different tools that you have at your disposal. Specifically, those are things like interrogatories, requests for production of documents, requests for admission, depositions, or subpoenas. Now, I'm going to talk briefly about what each of those is. Let's start with interrogatories. An interrogatory is essentially a written question. It's something that you write out, you send it to the other side, whatever the question is, and the other side has to answer it. They're required to do so within 40 days. Now keep in mind, you can't go crazy with this because you have a cap of 40 questions that you can send over, but that's the general idea. You can send it over to the other side, you can ask them whatever relevant questions you want to, and they have to respond to it, barring certain exceptions. Another commonly used discovery mechanism is a request for production of documents. Now, that one is similar in that you're sending the request over to the other side. They have to respond to it. Once again, they have to respond within 40 days, and if they don't, they can get in trouble with the court. And the difference there, though, is that with a request for production of documents, you're actually asking for specific documents or categories of documents that you're going to be seeking. So if you needed, say, bank statements from the other party and they hadn't disclosed that, you could send a request for production of documents and say, give me all the statements for XYZ bank, or all the bank statements you have generally, or something like that. If you had a securities account, like a stock account, something like that, you could do a request for production of document to get those statements. If you needed some sort of medical record, sometimes that can be involved. So the document range, the types of things you can get there is pretty broad, but if what you need is a document from the other party, you can use the request for production of documents to get there. Another major thing you can use is request for admission. Request for admission is similar to the interrogatory in that you're writing things out and the other side has to respond. The major difference here is that with a request for admission, you're making a statement and you're asking that the other person, the other party, either deny or admit to that statement. So it could be something like, admit or deny that you've never seen your kids ever. And then the other party has to respond either by saying admit or deny. And like with everything else, there's a 40-day response time on these. You have a cap. You can only ask up to 25 of these. But the other side has to do this, or else, once again, they can get in trouble with the court. Now, some people will actually piggyback on interrogatories to the request for admission. And one way you can do that is, say, for example, you have a request for admission that says admit or deny this thing. And what you can follow that with then is an interrogatory that says, okay, if you denied that, explain why, or explain your rendition of events, or whatever. So request for admission is another tool you can use, again, sometimes in conjunction with the interrogatories. Now, another mechanism you can use is called a deposition. Depositions are nice because they give you sort of free rein to just ask any relevant questions to what's going on, or anything that can lead to relevant information. So you essentially bring the other party in, or some other party. If it can be someone that's not involved with the case, it's usually in family court the other party in the case. But you bring this person in, you sit them down in front of a court reporter, and then you just ask any of the questions you have. Typically everybody shows up. If you're represented, if the other party's represented, they'll bring their attorney. If you're represented, your attorney will show up. Either party can be there. The one being deposed has to show up. The person that is doing the deposing, if they have an attorney, they usually have the discretion of showing up or not if they want to. But that's a deposition. One of the major drawbacks of depositions is if you're using an attorney, they can be very expensive because you're dealing with prep time for the attorney, the court reporter's time, the cost of preparing a transcript after the court reporter is done. So it can get very costly very quickly. But that said, you can also get a lot more information a lot more quickly. When you use something like an interrogatory, those written questions, a lot of times people will not give complete answers, so it doesn't give you a really quick mechanism by which to just follow up. So the deposition can be very useful in just getting everything you need, kind of following up with immediate questions, that sort of thing. The last major mechanism we're going to talk about is the subpoena. Now, the subpoena is very useful for dealing with people outside of the court case. Typically, if you've got some other party other than the opposing party that has some sort of documents or evidence that's going to be relevant to your case, you can issue a subpoena to them. And the subpoena will essentially just say, hey, other party, hey, other person, third party to this case, you need to provide XYZ documents. Now, this can be useful if the other party isn't quite complying or is very non-responsive or slow to respond to some of the other discovery requests you've sent out. So, for example, let's say you send out a request for production of documents to the other party and they don't give you bank statements. And you need those bank statements to prove your case, or you need to know what's in there so that you can determine whether or not it's appropriate to proceed on something, or for whatever reason you need those documents. You could then turn around to the bank directly and issue a subpoena, and then the bank has to disclose those documents. Now, with all of these things, there's various rules, various protections that the other side can have, objections that people can make. There's lots of things you can do with them. So they can be a little more complicated than what I've described here, but in a nutshell, that's what you're dealing with in discovery. And those are the different tools you have to find information that you need for your case. You have the interrogatories, the request for production of documents, the request for admission, the depositions, and the subpoenas. And if you need help with any of these things, please feel free to call us, contact an attorney, if not us, that is versed in family law in your state, if you're not in Arizona, and best of luck.